Hello and welcome to The Print. I'm Apoorva Mandhani and I have with me former Chief Justice of Orissa High Court and now a senior advocate, Justice S. Muralidhar. Dr. Muralidhar needs no introduction, but I'm going to give a brief one anyway. Like I mentioned, he's been the Chief Justice of Orissa High Court. He's also served as a judge in the Punjab and Haryana High Court as well as the Delhi High Court. He's a senior advocate now and he's come up with his new book. It's called Incomplete Justice. The book is in a way a review of the performance of the Supreme Court over the past 75 years. It tells stories, it talks about its landmark judgments, it talks about the sort of cases that the court is taking now and has been taking over the past 75 years. And it talks about the sort of administrative changes that have been adopted by the Supreme Court. So it really takes a very wholesome and 360-degree view of the Supreme Court and its performance over the past 75 years. We, of course, hear Justice Muralidhar's voice in the book, but we also have essays and interviews with several former judges, leading practitioners, as well as legal scholars who address and debate on different issues and questions that usually come up in our minds, covering the court and in our viewers and readers' minds. Thank you so much for joining us, sir.
Thank you.
And congratulations on the book. We have a copy here to show our viewers. So before we delve into the book, I'd like to ask you that, of course, you're practicing now, you're a senior advocate. You had an extensive practice even before you were elevated to the bench.
That's right.
But has your way of strategizing for cases changed after having been a judge? Has that impacted it?
Certainly, because what you get to see as a judge is like what you mentioned a few minutes ago, 360-degree view, where you're not looking at it only from the point of view of the two parties, but also where the law is going and whom are you dealing with. So that is a very special experience as a judge, which you don't get to see as a lawyer. So that has kind of helped me. Now I'm also able to gauge the mood of the court better.
Okay.
I know when judges tire, when their attention span, wavers. So if it's going to be a very heavy case, the judge is not going to be inclined to take it up. So you're conversing with the judges is of a different kind now. So that changed. But as an institution, I can see changes in the sense that judges are in a greater rush now. The workload hasn't decreased one bit. So the number of days that were allocated earlier for fresh cases is increased. So now you have a non-miscellaneous day. And then you have even, lawyers mentioning cases before judges for not to be deleted.
Right.
So this is all new. I mean, I wasn't during my earlier years of practice, this was not happening. And very few days are actually allocated to final hearing of cases. So everybody, I would say, is what we call a miscellaneous mode.
Right. So, of course, it's a very unique viewpoint also that you bring to the book. Now, let's get into the book. How did the whole idea come about?
See, 75 years is a landmark. And earlier I was associated with Supreme But Not Infallible, the book that came out at the 50th year of the Supreme Court. So this is a good enough time to take a look, take stock, look back, and then see where we are headed. And so much has happened. Actually, in the last 10, 15 years also, a lot has happened. So this taking stock is important. Second, what I find is when courts bring out commemorative volumes, they are largely self-congratulatory.
Right.
And they tend not to, deal with issues that could become controversial or where there's a lot of explaining to do. So they simply avoid that. So it's always what is called only the good news. And even when we talk about judges, if you've been to so many farewells,
right,
and always only the best things are said about all the judges. Everybody is a jurist and everybody is, the court will not be the same without this person and all that. So we don't really do a critical analysis of the functioning of a court. There are good things and there are not so good things. And we should be able to say that without fear of contempt or, in an objective way and in a language that is acceptable. So these are all very seasoned scholars.
Right.
Very seasoned judges, scholars and very good writers. But what I think unites all of them is a degree of fearlessness. You need that. Because as a journalist, you yourself think twice, thrice. Your editor thinks thrice before publishing a story saying, okay, let me send it to the lawyer that we know to vet it, whether it will pass muster in a court and all of that. So as a result, what has happened is a kind of self-censorship that has crept in. So this book tries to do what is supposed to be doing, which is legal scholarship, which will hold a mirror to the court and help actually progressively for judicial reforms and course correction.
Do you think that's how this book also differs from all the other sort of reviews of the Supreme Court that have come so far?
Yeah, depending on who's done it,
Hmm.
yes, if it is commissioned by a court, then it has a certain tenor.
Right.
And it's unmistakable.
Hmm.
So when you keep that volume and this volume, you'll know what I'm saying.
Okay, now diving right into the book, in the introduction of the book, you mentioned several highs and lows of the Supreme Court
Correct.
over the past 75 years.
Right.
For our viewers, it's a very simply and beautifully written book in case you want to pick up a copy. It's very well communicated for a larger audience. Now, there was an unprecedented press conference that happened in 2018. You mention it in the book. It was done by 4 senior judges of the court back then. They said, and I quote, they had no other choice but to communicate to the nation to please take care of this institution. This press conference itself has been deeply polarizing. From what I have seen as a journalist, even the legal community is often divided about whether it was a high point or a low point in the history of the Supreme Court. What, according to you, was it? How would you label it?
So the low point was the breaking of trust among the senior judges of the court. See, one of the things about post 1993 is that the senior judges come together to take very important decisions on who should be appointed to the High Court and the Supreme Court.
Right.
So a certain degree of collegiality is implied in that, and there should be a free exchange of views. So even on the issue of master of the roster, what normally happens is there are no rigid rules. There are what are called silences in the Constitution. We expect the person occupying the seat of a Chief Justice of a High Court or of the CJI in the Supreme Court not to be told what should be done. Usually it's a very experienced person, but it becomes necessary for you to keep consulting your colleagues, even on matters of fixing the roster. Of course, the power vests in the CJI. There's no doubt at all. Nobody can dictate to the CJI, this is how you're supposed to fix this roster and that.
Right.
But as a senior judge, and your colleagues are all senior by then, you normally have conversations, take them into confidence. And I found that had broken. If you read that the press conference happened in January,
2018,
the letter which they released was in November. So they had waited patiently. They had hoped for a dialogue with the CJI. That dialogue didn't happen. That letter didn't have the effect, and therefore they went for the press conference. So the low point was not the
press conference
itself. The low point was the break of the trust among the senior members of the judiciary, then being played out in the open.
Now, since then, it's been 6-7 years since then. But the master of the roster's powers of the Chief Justice, they keep coming up in debates. There's a lot of concerns that are raised about listing of cases till date.
Exactly.
Do you see that as a concern? Firstly, if yes, do you have a possible solution for it?
Yeah, so it is a concern, no doubt. The solution that somebody like Panchu in the interview I have had with him, he's suggesting that just like we did it with the appointments process, can there be a collegial process for even this? But from my point of view, that's impractical. I've been a Chief Justice myself. Very often files are brought to you the last minute and, you have to suddenly decide, or somebody recuses and the matter has to be heard the next day. You have to fix a bench for that. So this can happen through consultation, also being sensitive to the reactions around you. See, the bar constantly gives you feedback. Having been a Chief Justice of a High Court, I get feedback constantly on whether, there's in a particular court, things are moving as they should, or are cases piling up, whether a judge is delivering judgments on time, whether a judge is uploading orders on time, whether a judge understands the subject matter or not. It can happen.
Okay.
Suppose I've been a tax practitioner. I'm now sitting on a criminal roster. Everything will look like, completely strange. So some people don't realize that all judges are not the same. All judges are not of the same capacity. All judges are of not the same training. So let me say that I'm a copyright, patent, trademark lawyer, top of my field on IPR. Today I'm deciding a human rights case. I've never done that case as a lawyer. It can happen that since I'm bright, I can pick up the main issues, but I may still be unfamiliar. And lawyers dealing with human rights cases, when they argue the cases before me, within 5 minutes, they will know whether I'm familiar with the subject matter or not. So there's also a humility that is expected of judges where you learn from the other. Now, this kind of a feedback goes to the Chief Justice through the bar, through all other kind of sources. So if I know, like for instance, the bail roster, nothing is moving. A bail roster has to move very fast.
Right.
And if in every case I say no, no bail, no bail, no bail, the criminal bar will be, up in protest, because they've seen several generations of judges. They know, what is a passable case and what is not. And if they find that I'm such a tough judge that I will not grant bail at all, that feedback goes to the Chief Justice. Then either I call the judge saying, are there issues? And I have had a very senior judge tell me, who retired from the Supreme Court, that he was a civil law practitioner. And he was in the then undivided Andhra Pradesh High Court. He was given the bail roster. He said, every time I picked up a paper book and read the FIR, my heart would sink. And for the first 2 days, I didn't grant bail in a single matter. But being a sensitive judge, he got the feedback through his ushers and through other lawyers that, listen, the criminal bar is furious. So he goes to the Chief Justice and he tells him, listen, I can't handle this roster.
Okay.
So at least the judge should do that. So when this master of the roster is a very sensitive function, it should be handled very carefully, and it should inspire confidence. And although we can't rigidify it with rules, we need, some degree of orientation for this. Okay. You watch and learn. There have been so many Chief Justices of so many High Courts, so many CJIs. Why did they not have these problems? So you talk to them, you find out what's the best way to do this. How do you inspire confidence?
From what I understand, you're in fact asking for a more human element to be introduced in this maybe. But there have been a lot of suggestions where people suggest maybe it should be technology based. Maybe that should
It might break down. See, technology, like we did have a software in the Delhi High Court for allocation of bail applications. Lawyers being lawyers, if they know that it's gone before a judge who's not likely to grant bail, they'll find some way of getting a lawyer who's somewhere related to the jail to file a wakalatnama. And then the judge says, no, not before me. So this is an oldest device. The bar is so old. I'm talking of probably this was there from the 19th century itself. You don't know. But as lawyers and judges, we're aware of all this. So when the initial allotment through the computer fails because the judge is recused, the second allotment can't happen through the computer. It will still have to come to a human element, which is a judge. The expectation is exercise of that power honestly and, for the purpose for which it is given to you.
Since you mentioned bail as an example, I would like to take you there on, although I have more questions on appointments, but we'll keep that aside for a second. How have you seen bail jurisprudence evolve? Because from the examples, of course, in the news, we see very few examples coming up, just the prominent cases. But even there, a lot of times, bail isn't being granted as often as maybe it should be when we say that bail is the rule and jail is the exception. Do you see that phrase actually coming into practice now,
so
or has that changed?
The coercive element of criminal law, it's tested at this bail point, right? The minute you say getting a bail is going to be very difficult, look at the standard set of provisions which were introduced in the Narcotic Drugs and Psychotic Substances Act. The burden shifts to the accused to show that he has a prima facie case. And hearing the prosecutor is a must. So the court's hands are tied. So you can't, without these two steps, you just can't proceed to grant bail. And then it's hemmed in with the quantity, commercial quantity, this, that. Now, if you remove these two elements, then it becomes like any other, criminal law. These are the coercive elements. What has happened over the last few years, this coercive element has got transplanted into a series of statutes. Not just the UAPA or some, anti-terrorism law. It's gone into the PMLA law.
Right.
It's gone into the, SFIO, into the Companies Act. So you're now making it impossible for bail to be granted. Now, as a court, if there's already a kind of a deterrent on the court to grant bail, it's percolating to all other cases as well. So today, lawyers across the country will tell you how the district judiciary is reluctant to grant bail. Now, there is a parallel jurisdiction on anticipatory bails with the district court, district and sessions court and the high court. Normally, they should be going to the sessions court. But any criminal law practitioner will tell you it's pointless going to the sessions court with an anticipatory bail application, let's say in some case involving even 7 years imprisonment, because he knows for a fact it will not happen there. And what happens also is, it's so easy to give a complaint against a judge granting bail, saying he did it or she did it for extraneous purposes. Then a complaint goes to the High Court. A vigilance inquiry is started. There have been instances where strictures have been passed against judges in the Sessions Court for granting bail. So there's already a chilling effect.
Right.
Now, this goes to the level of the High Court. In the High Courts, we find judges are reluctant to grant bail. So everybody is having to come to the Supreme Court. Today, we have a Supreme Court of India with 34 judges, with many benches dealing with bail and anticipatory bail applications. This is a marked change from what it was when I left the court to become a judge in 2006. Much of the court's time is taken on anticipatory bail applications. I didn't really expect it to come to this. So this needs course correction. Although judges do say on public platform that bail is the rule and jail is the exception, when it actually comes to individual judges and courts, they say, let the Supreme Court do it, let me not do it.
So course correction, where should it come from? Should it come from the legislature? Should it come from top down from the Supreme Court?
One is not to punish any judge or to, make adverse comments because the judge is in public through judgments or orders because the judge has granted bail. That's a correctable, it's a judicial order, it can be corrected in revision or at a higher level in the High Court or the Supreme Court. So let the judge not be in fear of granting bail. This has to happen by actual action.
Okay.
And not merely talking. And you should be able to say that, okay, this month, there were so many bail applications before the court and we've done slightly better than what we did last month.
So proudly claim that we've done better.
Some positive messaging has to go that I've had Supreme Court judges say in exasperation, offense punishable up to 7 years and you're here in the Supreme Court for this. And, the second factor is how prosecutors behave, how law officers behave. They are supposed to get up and frankly tell the court, listen, this is a case for grant of bail. But you will find them opposing every bail application tooth and nail.
Right.
And even if the man has spent 5 years, 6 years without trial, they'll say, no, you should refuse bail. So that, I think, also needs to improve, where we expect prosecutors to actually assist the courts, give the courts the confidence. Okay, these are the cases where you can grant bail. Maybe there are a few smaller percentage where you cannot. You have prisons overflowing. So what are we doing? We can't complain of that and also do this, right?
Right. Okay. Now bringing you back to appointments and transfers. Now both Justice Shah and Justice Lokur in their respective essays talk about transfer of judges. Justice Lokur mentions that the subtext often with regard to transfers is that it was a disciplinary measure. And he says, and I quote, "It is difficult to appreciate how the administration of justice is served by transferring a judge from one high court to another. In my view, if a judge is not good enough to be retained in the parent high court, transferring him to some other high court is an injustice to that high court," unquote. Now, lots of questions, of course, were raised about Justice Verma's transfer recently after the allegations emerged against him. This was a transfer from the Delhi High Court to his parent Allahabad High Court, and the Allahabad High Court Allahabad High Court Bar Association was up in arms against this transfer. Do you think the transfer of a judge is the correct course of action in such cases?
See, it doesn't. I would tend to agree with Justice Lokur that a wrong message is going out. So you find there are two kinds. There have been judges who say, my son or daughter is now, qualified as a lawyer, is enrolled. Please transfer me out of this court. You don't write these stories. You only write the negative stories. There have been actually judges who have voluntarily sought transfer.
Right.
So that transfer is not stigmatic, obviously. But we have no way to communicate to the public that this is a stigmatic transfer and this is not. But what happens is certain high courts are known as some privileged courts. Whatever we may say that, all high courts in the country are one and there's no difference between one high court and the other. I think we take it with huge sacks of salt. Everybody knows transfer to the Delhi High Court is not a punishment transfer. It's like kind of a step up.
Right.
Or transfer, to the Guwahati High Court or the Sikkim High Court is not a step up. So this everybody understands, including the judges themselves. So the messaging, therefore, that has gone is that we understand which are stigmatic and which are non-stigmatic. And then, if that is true, then those high court bars are justified in asking, okay, if you find that this judge is not good enough for Delhi, how is this judge becoming good enough for Calcutta or Allahabad, right? Or Madras? Naturally, the bar will wonder. So, Lokur is right. Justice Lokur is right in saying that this is not resolving the problem. It's only relocating the problem. It could be that that judge gets chastened and says, okay, this is a way to course correct for myself. But that's not the answer in terms of a constitutional framework where you are supposed to deal with judicial misconduct in a
Right.
more frontal way. So I would urge you to look at the Law Commission reports, where we found that in between, it can't be all or nothing, which is impeachment or nothing.
Right. Okay.
There has to be something in between. The judicially devised method is this transfers. And this is having a lot of heartburn and misgivings. And it's not a satisfactory way of dealing with it. And it makes it even more opaque. And the last thing I wanted to say on this is the judge being transferred is not told why.
Okay.
And then there's a complete violation of natural justice. I'm transferring you, you don't know why. And I'm saying, I'm giving you 2 days to respond, whether you agree to this or not. I mean, what are you supposed to say?
Yeah.
Even when you say, sorry, sir, I disagree, it's going to make no difference. I'm just going to say, oh, I've read your response. Here is your transfer. So this ritual that we go through of informing the judge and saying, do you have anything to say, is a meaningless ritual. And there is actually a violation of natural justice because the judge never gets to know what are the real reasons for the transfer.
That actually very comfortably brings me to my next question.
I must just tell you, some of the judges who've reached the Supreme Court now, at one point they were transferred from one high court to the other, not knowing why they were transferred. They were transferred back to their parent court, again not knowing why they were transferred back.
There was a recent list also, very long one, where a lot of judges are being transferred and shuffled.
Absolutely.
Okay.
And what we thought was a stigmatic transfer, the next transfer is to the Supreme Court. So, so this is again a perception. Somebody you transferred stigmatically is obviously, it was not for valid reason then. How would that judge suddenly become good enough to be appointed to the Supreme Court?
So only inferences can be drawn because there is no
opacity. It brings us to the question of opacity. But opacity even within the system. I mean, for other persons to know or not know is one thing. Even persons being the subject matter of all of that, they have no clue why it's happening.
So your own transfer is also a part of the book. Of course, you've said that you had communicated your no objection for the transfer.
Yes.
But Justice Lokur wrote that in your case, and again, I'm quoting him loosely, he said that he got the distinct impression that the CJI was advised by the executive to effect the transfer. I know you've communicated your consent, but what was your sense at the time? At the back of your head, did you have that inkling, or now thinking about it since some time has passed since then, what's your sense of what happened at that time? Because the idea for our viewers was that at that time there was a lot of controversy around it because it happened right after an order that Justice Muralidhar had passed in the Delhi riots cases. This was in 2020. So what was your sense at the time?
No, see, I think many of us watch the system. We know where we stand vis-a-vis the system. And it doesn't matter. A judge like me, it doesn't matter if it's government A or government B. I'm just looking at the act of the government which is under challenge before me. And that has to be decided on its merits. I know it produces a certain kind of reaction. So I'm not oblivious to it. So I was not surprised, if that's what you're asking. I was not surprised. But the timing of it was something that they had to think about because they were making it so plain. Something that was there in the pipeline. If it suddenly happens overnight, then they are the ones to answer that, right? Not me.
Right. Okay.
Like even in the collegium, what Lokur is talking about, how the CJI of that time tried to push. And first he said no, and then Justice Sikri said no. The questions have to be asked of them. What was that happening which made them do those things?
Right. Okay. Now, I had about appointments. I had written a series of articles on prevalence of family lineages in judicial appointments. We had found that at least 30% of sitting judges of the Supreme Court are related to former judges. Another 30% have parents or grandparents who've been lawyers, so second or third generation or even seventh generation lawyers. In high courts, 1 of every 3 sitting 687 high court judges were related to sitting or former judges or come from a family of lawyers. When we talk about judicial appointments, we do talk about diversity a lot, of course, in terms of, say, gender or caste. But is this the sort of diversity that we should be looking at as well with regard to maybe encouraging more first-generation lawyers on the bench?
No, we should definitely not compromise on quality.
Of course.
Like, I'm not one suggesting that a person is actually very good as a lawyer, but because he happens to be a judge's son, we should not appoint him.
Absolutely.
That is also wrong.
Absolutely.
Right? But disclosures should be made. We're only talking about relations. In fact, I think I had the conversation earlier with you. We don't talk about chamber juniors. there's a huge nepotism around that too.
Right.
My colleagues, my junior colleagues, and their junior colleagues, they'll all get a special dispensation, and if the time is right, all that too also happens.
Right.
And children of judges who are lawyers are placed with law officers. So that's another kind of thing that people are not noticing.
Absolutely.
They get entries into the offices of the Advocate General, the Additional Solicitor General, maybe even the Attorney General. So we're somewhere oblivious to all of this. What is the messaging that is going out? Right? You may say, no, they are all perfectly competent, capable lawyers. But this is about the justice seen to be done factor.
Right.
They can wait. They can wait till this period is over and then join the office of the Solicitor General, maybe, if you're sensitive to that. So this is a question of perception matters in the judiciary. Like, I am the CJI and somebody closely related to me is being considered. It comes in the newspaper that I have recused. But that's not enough, right? If I'm today the CJI, I'm going to cease to be the CJI, let's say 4 months hence. This appointment can wait till I move out of the office, right? Like, Justice Kabir and his sister being appointed. I mean, it left a very, very bad impression, extremely bad impression. There was no need for that.
Right.
And I think she was already some 59 or 60 when her appointment was being considered, which is a departure from the norm. So I'm just saying there are so many instances where we can avoid these controversies easily. It's in our hands to do it. We don't need anybody else telling the judiciary about this. We are fully conscious of what we're doing. And we can easily avoid these embarrassments.
Now, one of the questions that you raise in the introduction of the book is, given the quick overturning of its verdicts of its larger benches, is the court undermining its position as final arbiter of disputes? This is the question that you raise. Now, apart from overturning, we've recently seen recalling of 2 orders also very quickly after the court passed them, with regard to one Allahabad High Court judge being barred from taking up criminal matters, and then in the stray dogs issue. What do you think about such instances? What do you have to say about them?
Yeah, actually, there should not be any hierarchy. There's no intra-court appeal as far as the Supreme Court is concerned.
Right.
This is a new trend. It started some years ago where the CJI's bench would simply put in abeyance a judgment of a coordinate bench. All completely unheard of. Completely extra constitutional, I would say. And there's a limit to 142. You can't just keep doing 142 for all these things. And it doesn't leave a very good impression. And it encourages what is called forum shopping.
Right.
And that's a very bad signal to give to the bar. Bar will pick it up. They'll say, oh, this is another avenue. Right? So you must actively discourage that. There are other ways of doing things. Like coordinate benches dealing with the same issue. One bench is told the other bench has already passed this order. So one bench is supposed to take note of that. But if as a lawyer, I know that you two don't get along, then it's very easy. It's very plain that you both judges think very differently. I can play up this. I need not tell you that the other bench has passed an order which is going to be inconsistent with the order that you are likely to pass, and encourage you to pass an order. And then tell a third bench, look, there are 2 contradictory orders. So all this should be avoided if we give a clear message that there's nothing called an intra-court appeal, that if there is a clash between coordinate benches, a larger bench is constituted to resolve that. That's the correct way of doing it.
Right. So it should come from within the court itself with the initiative of the CJI. Is that what you...
No, there is a system. Yeah, the CJI, usually papers are placed before the CJI for constituting the larger bench. But it will be based on a judicial order.
Right.
The bench which notices that there is another bench which has passed an order which is inconsistent with this order, and particularly if it's an earlier order, should normally say there is a clash of orders. We are placing the papers for constitution of a larger bench.
Right.
That's a correct way of going about things.
So I'll take one last question. Your section in the book on digitalizing the judiciary is very forward-looking, I felt, and it ends with a line. I'm going to quote it. It says, the Supreme Court of India of 28 January 2050 will undoubtedly be different, but in a positive sense only if it is still not grappling with finding solutions to the same problems faced by we, the people of India, when it began its journey 75 years ago. What, according to you, should be the court's priorities if it wants there to be positive changes in the next 25 years? You can maybe list the top 5 or top 3, whatever you want.
Yeah. first accuracy of data,
Hmm.
then correct analysis of that data in trying to find out which are the cases that need priority listing. Doing something to clear that kind of a backlog, 10-year-old cases, 20-year-old cases on priority basis, starting from the Supreme Court. We never seem to talk about 10-year-old cases, 15-year-old cases of the Supreme Court. We can start from there. If you use scientific methods, we can get rid of the backlog either by retaining judges past their retirement, because there is a provision for ad hoc appointment, again on merit, that a judge who's proven an efficient judge in disposing of cases and inspires confidence. Bar has always, Bar gives you a feedback on that. Those kind of judges can help you clear some of this backlog. But we need cooperation of the bar. And bar can't be kept out of all this discussion at all. It's like two ends, right? If the bar doesn't cooperate, none of these measures can actually go forward. And I'm expecting paperless courts.
Okay.
Where it's easier to walk through a court corridor or the branches of the court, easier working atmosphere, and far more transparency. The litigant should know what are the chances the cases will be taken up on a certain day, whether it will actually get decided, disposed of. That element of certainty has not still come into our system, even after 75 years. It has probably gone worse. So if these things get corrected, then we will be in a far better place in 2050.
Okay, I know I said one last question, but I need one last question now. Since you spoke about transparency, just to speak a little bit about the trust in the judiciary generally, how do you see that graph over the past 75 years?
Surprisingly, I don't see the trust having gone down. See, when compared to the legislature or the executive, I invariably have people saying, ultimately, it's only the courts you have to turn to. So everybody, every walk of life, that's the one hope they have. That there'll be some judge or some bench at some point in time which will see their point of view. And it has happened. Every now and then you get some positive order, you breathe a sigh of relief.
Right.
Those two, Karan Thapar and Siddharth Varadarajan, they went to the court the other day. The thing was stayed. I'm sure you were very relieved to read that, correct? As a person in journalism.
Of course.
So every now and then something like that positive happens, you say, acha, theek hai. There is still hope. But across, this Project 39A square circle,
of course,
those young lawyers, such great deal of commitment, they've visited jails, unearthed stories, given life and hope to prisoners. And through them, cases have been litigated up to the Supreme Court and justice has been done. So for those kinds of people who are otherwise hidden and invisible, suddenly there's hope. So it may be that not all 34 judges will decide the same way as, let's say, one bench decided in one particular case, but it still gives hope. So I don't see the trust going down, but I think we should earn that trust and not merely command it.
Okay, on that note, we've reached the end of this interview. Thank you so much for joining us, sir. And thank you for all our viewers for watching. I hope you enjoyed this interview. Do let us know in the comment section.